Okay, well, good afternoon. On behalf of the Nathanson Center, very welcome. We have a nice spread for lunch, so please, during the talk, feel free to come and help yourself. Today, we're very honored to have with us Professor or Dean Timothy Endicott, who is the Dean of the Faculty of Law at the University of Oxford and has been so since October 2007. Professor Endicott is also a fellow in law at Balliol College in Oxford and has been professor, and when I say professor, I mean professor in the real kind of professor, right? It's the British kind of professor, the highest echelon of the academic hierarchy. He's been professor of legal philosophy since 2006. Now, Professor Endicott writes on jurisprudence, otherwise known as general legal philosophy, which most of you will know, and constitutional and administrative law, with special interests in law and language and interpretation. He's the author of Vagueness in Law, published with Oxford University Press in 2000, as well as Administrative Law, the definitive statement of English and British administrative law, published with Oxford University Press in 2009. Now, after graduating with an AB in Classics and English, summa cum laude, from Harvard University, Professor Endicott completed his MPhil in Comparative Philology in Oxford, and he's studied law at the University of Toronto and practiced as a litigation lawyer in Toronto. He completed his doctorate, his DPhil in legal philosophy in Oxford in 1998. Now, it's a real pleasure to have Professor Endicott with us today. Professor Endicott, for me, is more than just a colleague, somebody to look up to. He's somebody who's done a lot for me. He was my college advisor at Balliol College in Oxford and also one of my doctoral examiners. So if I'm here today in front of you, it's partly thanks to Professor Endicott. So Professor Endicott today will speak to us about proportionality and the crisis in European rights adjudication. So once again, a very warm welcome to Osgoode Hall Law School. Thank you very much for being with us, and the floor is yours.
Thank you very much, Francois. And Francois, and first of all, I'm sorry I arrived late. I'm quite familiar with Osgoode Hall Law School. My dad went here when I was 14 years old, and so I feel like part of the place. But I didn't foresee the wonderful traffic jam on Keele Street, and it looks very promising, and I hope that it means the subway is going to be coming up here soon. So I'm sorry I'm late. Remind me, Francois, how long I get to talk for?
How long do you want?
40 minutes or so?
40 minutes,
good.
And then we can follow by a short Q&A.
Well, I wanted to make sure there's enough time for discussion at the end of what I say, because I'm going to make you a deal that, as Francois mentioned, I'm going to talk about proportionality and human rights adjudication. It's something I'm working on. And last week I read the quite amazing decision by the Supreme Court of Canada in the Insight case concerning a clinic where addicts to heroin and cocaine can inject themselves with these illegal narcotics in downtown Vancouver. And I'm going to stick my neck out and make some comments on what the Supreme Court of Canada said about proportionality in that case. And the deal with you is that if I'm willing to do something so rash as that, because I've been away from Canadian law for quite a long time, I'm hoping that you will contribute to my understanding and help me to work out what's going on in that case, and perhaps in other aspects of Canadian law on proportionality. And one of the themes that I think you'll see is that what's going on in Britain and Europe is connected to, and I think they've borrowed from, what the Supreme Court of Canada has done in the past. And my part of the deal will not be just to say something rash about the Supreme Court of Canada, but to tell you a bit about what's going on in human rights adjudication in Britain. It's in a sort of crisis, a sort of political crisis, a crisis that's been generated by one particular case, which is a decision of the European Court of Human Rights in 2005 that a blanket ban on voting by prisoners who are in prison on sentence is contrary to the European Convention on Human Rights. that one case has generated a political crisis over the role of the European Convention on Human Rights in British law. And I want to tell you a bit about it and comment in particular on the role of proportionality in this ongoing crisis. I won't assume that you know about the European human rights regime. I'll tell you a bit about it. And I'll start with some of the really striking things that judges are doing with human rights, with the European Convention on Human Rights in Britain and across Europe today. There's the European Convention, and of course some of you will know this, but I'm going to assume you don't, includes everything that we cherish in the Charter, apart from the Aboriginal rights and language rights, and a right to respect for private and family life in Article 8 of the Convention. And the judges have interpreted that the Convention to prohibit the deportation of a criminal who has no right to be in the United Kingdom and commits a criminal offense, drug trafficking or theft or burglary or rape or murder. The Convention, the right to respect for your family life, prohibits the deportation of such an offender if the effect on his or her family life would be disproportionate to the public purpose in immigration control. And also, it prohibits such a deportation if the effect on the family life of his or her partner or little child would be affected in a way that's disproportionate to the public purpose. Here's another example. There's a right to a fair trial in the European Convention on Human Rights, as you would expect, and it was interpreted in one case to restrict the use, or even potentially to prohibit the use of jury trial on the grounds that in a fair trial, the person subject to a sanction learns the reasons for the decision, and in a jury trial, the jury doesn't give reasons. There's a duty in the European Convention to hold free elections that represent the will of the people, and as I mentioned, the European Court of Human Rights has decided that it prohibits a blanket ban on voting by prisoners. Just in July of this year, the Grand Chamber of the European Court of Human Rights decided that the Convention, or at least the right to life in the Convention, extends to people subject to alleged abuse by British troops in Iraq, a dramatic extension of the scope of the Convention, which I'll comment on. The judges are doing remarkable things, and Canadians are used to the judges doing remarkable things once you give them a set of abstract rights and ask them to decide what they require in the litigation process. And the British didn't expect this when they signed up to it. The British took a leading role in developing the European Convention on Human Rights, starting in 1949, and Winston Churchill was all in favor of it. And they set out this charter in negotiation and joint drafting with lawyers and politicians from around the continent. And they agreed from the start that there would be a court that would have jurisdiction to decide what the rights require. That court did not initially take petitions from individual complainants of alleging that their own rights had been violated, but only heard cases brought by one country against another. That changed in 1966 when the countries in the Council of Europe, this is quite separate from the European Union, by the way. The European Union started later than the Council of Europe out of free trade arrangements over steel and coal, and developed into a sort of economic and partial political union of many states in Europe. The Council of Europe started out earlier and set out to protect human rights across Europe. In 1966, the countries of the Council of Europe agreed that individuals would have a right to bring claims to the Strasbourg Court, the European Court of Human Rights. The European Court of Human Rights is composed of one judge from each country that's a member of the Council of Europe. Today, that's 47 different judges. They sit in panels of 5 or 7. And in a grand panel, a grand chamber, for major cases or for rehearing matters that have been decided initially by a panel of the court, the grand chamber is 17 judges out of the 47. So the whole body never sits. 47 is a large court, but it's not nearly large enough for the volume of cases they have today. The volume of cases was very low in the 60s and 70s and 80s and 90s. And in 1998, they amended the process of the court in a way that just made the caseload of the court explode. And today they have a backload of tens of thousands of cases, and there were 50,000 petitions made to this judicial institution in 2010. Very many thousands of them coming from Russia, and the convention now extends beyond Europe to all of Russia, beyond Europe to Turkey, and it is in a judicial institution that is based on nomination of judges by the individual countries that are members of the Council of Europe. And those out of the 3 nominations from each country, when there's a vacancy on the court, the Parliamentary Assembly of the Council of Europe decides which nomination to approve. And this process of appointment is not very satisfactory. It's under review. The caseload management is under review. Britain has just taken over the rotating 6-month chairmanship of the Council of Europe, and they're determined to reform the system in ways that I'll come back to once I've pointed out the reasons for the political crisis in Britain. And the thing that they're really going to have to do, and perhaps can be done, is to deal with the caseload management problem and reform of the judicial appointment system. And I think those ought to be high priorities for reform. What they would like to do is to reform the system so that there is a different balance drawn between the powers of the Parliament of the United Kingdom on the one hand and the powers of the Strasbourg court on the other hand. And one of the conclusions of what I have to say will be that there's no better prospect of them achieving that sort of reform than there would be of the Harper government trying to redress the balance between the Canadian Parliament and the Supreme Court of Canada in the application of the Charter. And I'll try to explain why I think that's the case. And let me also just mention, so that those of you who aren't familiar with British law will understand what's going on. Another change in 1998, the same time that the court structure was reformed in the Council of Europe. The British Parliament, as one of the constitutional reforms brought in by the Blair government, one of the first, passed the Human Rights Act, an act which does not, as it's often described, entrench the Convention on Human Rights or incorporate it into British law, but gives certain effects to some, in fact most of the rights in the European Convention in English law. The Human Rights Act makes it unlawful for a public official or public body to act in a way that's incompatible with the rights in the Convention, unless a statute of Parliament requires them to do so. If a statute of Parliament requires them to do so, then there's nothing the courts can do except to declare that the statute itself is incompatible with the Convention. If a court issues a declaration of incompatibility, that does not affect the operation of the statute, does not change the law, except that it triggers a fast-track process in the British Parliament for reform of the incompatible legislation in a way that doesn't require the ordinary process of 3 readings in both houses of legislation. So a declaration of incompatibility by the courts gives the government and Parliament a technique for quickly reforming the legislation to make it compatible with the Convention. Now, if you ever hear a report by the BBC or read about it in one of the papers, and the papers that use big words, not just the tabloids, if you read in the papers or hear on the BBC an account of one of these declarations of incompatibility, they just don't get it, and they always say that the courts have struck down the Criminal Justice Act or provision of the Criminal Justice Act. In fact, of course, they haven't. And yet, as the politics of the Human Rights Act have developed, the declarations of incompatibility have had a rather similar effect. The government always treats it as a necessity to make an amendment to legislation through that fast-track procedure to make it compatible with the judge's view of the European Convention on Human Rights. So the Human Rights Act gives to most of the rights, including all the ones that I'm going to talk about today, a rather similar effect in practice to the effect of the Charter in English law. The big difference is the joint role of the English courts and the Strasbourg court. And Section 2 of the Human Rights Act requires judges in England to take account of decisions of the Strasbourg court in the interpretation of the Convention. And there's an ongoing, and I think more or less irresolvable, difference of attitude by different judges in the highest court, which since 2009 has been called the United Kingdom Supreme Court, the successor to the House of Lords. There's a difference of attitude among the judges as to the import of this requirement to take account of what the Strasbourg court is saying. Some of them say, well, we just have to take it into account, and if we and we should give the right interpretation of the European Convention, not a mistaken interpretation that happens to be the interpretation of another court, which has no power to override our decisions and does not make decisions under the Human Rights Act, and the Human Rights Act certainly doesn't bind us to follow decisions of the European Court of Human Rights. That's one attitude. The other one, which really was Lord Bingham's attitude before we lost him to, he died just after retiring from the House of Lords last year. His attitude was that it's an international convention we're talking about. It needs to have a uniform interpretation. The only body capable of that is the European Court of Human Rights, and it's authorized by the Council by the Convention to interpret the Convention. So we English judges, Lord Bingham reckoned, ought to give effect to the Strasbourg decisions. What's more, if we don't, the losing party in our court is just going to have to spend another 4 years going to Strasbourg, or today it could be 7 years because of the backload of cases. And the Strasbourg court will do what it sees fit. So we ought to, barring some hypothetical exception, give effect to Strasbourg decisions. So on either side of that judicial difference of opinion, they're really stuck in Britain with the decisions that they get from Strasbourg. Because even if the judges, and some of them on the Supreme Court do disagree with Lord Bingham today, even if the judges don't go along with what Strasbourg says, the losing party will be able to go to Strasbourg for the Strasbourg interpretation. So the Strasbourg court has the final decisive jurisdiction to decide what these rights require. And that, I think, it lies behind the political crisis that is going on in Britain today. The political crisis has been, in my view, it's surprising that the political crisis didn't arise wasn't generated out of cases like the one I'm going to discuss on proportionality, on the deportation of illegal immigrants in Britain who have committed a criminal offense. That strikes me as a greater interference with British government policy and the policy of the British Parliament than the case that generated the political crisis. And that's the case over voting rights, a case called Hearst that I mentioned in 2005. They did the same thing that the Canadian Supreme Court did roughly in the Sauvé case. Perhaps they weren't quite as forthright as the Canadian Supreme Court about the essential role of the vote in the dignity of the human individual. They did the same thing as the Australian High Court, which has struck down blanket bans on voting in Australia on similar grounds, using, of course, they don't have a Charter of Rights, but they've done it using the requirement of free elections in their constitution. Now, in Canada, I'm not aware that this decision, and doubtless there were people who disagreed with it, and presumably deeply, and it is a very deep, remarkable opportunity for us to disagree with each other. And by the way, if you want my view on prisoners voting, I think it's a good policy to give the vote to prisoners, by and large. That's what I tend to think. I just find an air of make-believe in the argument that it's an abuse of their human rights, and people point out what a fundamental right it is, and that's true in a democracy. Of course, it's not a right at all in a non-democracy. It's a fundamental right in a democracy, and it seems to me much, much less fundamental to the life of the human being than the right to liberty of the person. And it seems to me quite striking that there is no debate over our penal system in respect of the right to liberty. And I'm not aware, maybe this has been litigated in Canada, but nobody in Britain has tried to argue that a deprivation of liberty on a sentence of the court, sentence of imprisonment to 10 years for a serious crime, for rape or for manslaughter or burglary, is an abuse of the human rights of the offender. And yet it's such a striking, destructive thing to do in any penal system, in the best penal systems in the world. Remarkable, and the taking away of the right to vote strikes me as trivial by comparison with what we do, what it's accepted that we do to serious offenders. So I don't really think it's a big deal, and yet I can see one argument in favor of giving the vote to prisoners, which involves dealing with them in a way that sets expectations for the future of their involvement in our community. Now that strikes me as a good argument. And I'm rather open-minded about whether it's an argument that judges ought to be imposing, contrary to the will of the legislature of Canada or of Australia or of Great Britain. So there, I just wanted to tell you that I'm kind of open-minded about it. The British politician, to generalize a bit, is not open-minded about it. David Cameron, the Prime Minister, he comes into office and there's this case and a decision of the European Court of Human Rights, and he's the Prime Minister of the country. He's responsible for leading the country in abiding by its international obligations. And here's one of its international obligations, not to impose a blanket ban on prisoners. And the Labour government, the Blair government and then the Brown government, they'd had since 2005, and they never got around to doing anything about it in time for the 2010 general election. Well, that's shocking. The new coalition government, Conservatives and Liberals, Liberal Democrats and Conservative coalition, they set about trying to draft some legislation that will do something. It's very unclear what will be enough. We know that a blanket ban, just because you're a prisoner, is, according to the Strasbourg court, incompatible. It's not clear what would be enough. Maybe we could say prisoners who have been in prison past 4 years or something. We don't know. There's one decision by a chamber of the Strasbourg court in a case from Austria saying that, and claiming that this follows from the Hearst decision, that the punishment has to be proportional. And that means that you could only impose a ban on voting if the offender had been guilty of a crime like voting fraud that would make the punishment fit the offense. And again, the air of make-believe when you think about what we're doing to offenders in every European country and in this country. You know, the suggestion ought to be that we could only imprison people who are guilty of kidnapping. I find, sorry, that's just the air of make-believe strikes me. But I just wanted to point that out because it shows that the British government didn't know what it would be able to do, and it didn't want to just open up voting to all prisoners. So they're trying to work out what to do, and they're preparing a bill. And then, as they're working on it in late last year, conservative backbenchers start to get really wound up about it. And in February of this year, there was a debate sponsored by a private member that generated tremendous outburst of emotion on the part not just of right-wing populist MPs who want to make a statement about how right-wing and populist they are, but across the mainstream of British politics. And 234 MPs voted in favor of a resolution that no prisoner should ever be able to vote, ever, and it doesn't matter what anyone says. 22 people voted the other way. And that's a shocking outburst of politicians against the United Kingdom's international obligations. The government, as a result, hasn't tried to pass legislation to give effect to the Strasbourg decision, and the situation is extremely unfortunate and unstable. And the only real solution for the British, if they want to deal with this, is to pull out of the whole thing. And that would be a violent thing to do in international politics, in European politics. It would be extremely destabilizing to the operation of a human rights regime that, with its foibles, and I think there are some, not just elements of make-believe, but serious problems with it, that has the potential to protect people from atrocities across Europe and today in Russia. Now, so I always thought that the British government would never actually seriously talk about pulling out of it. David Cameron set up a commission on a Bill of Rights as a gesture to respond to the political upset about the voters' rights case, the prisoners' voting rights case, which is a sort of, I think, a distracting sideshow. They're supposed to ask whether the Human Rights Act could be replaced by a Bill of Rights that would be differently drafted to redress the balance between Parliament and the courts. And in fact, that's futile because no rewriting of the Human Rights Act could solve the problem that under the European Convention on Human Rights, you can go to Strasbourg if your rights have not been respected in the United Kingdom. So that is a sideshow unless it were to come up with the proposal that Britain pull out of the European Convention on Human Rights. It won't do so. He appointed some real Strasbourg skeptics, some right-wing lawyers and politicians to this commission, but he's not a right-winger. I don't know if there's a right wing in British politics. There are right-wing strands in it. He appointed the politically correct, real advocates of what's going on in Strasbourg, lawyers who think the Strasbourg court isn't going nearly enough in taking the opportunity to impose a new vision of human dignity on the politicians. And so that commission will be deadlocked, and it's not going to propose that Britain pull out. And I'm glad to say that the British government is not going to propose that. There's a remarkable speech made by the Attorney General Dominic Grieve just last month. And I want to read you what he said to show that we can expect that, in my view, unless the future brought a collapse of the political system, the British are not going to pull out of the European Convention mechanism. Here's what the Attorney General said to an audience of lawyers: "There is no question of the United Kingdom withdrawing from the Convention. The United Kingdom signed the Convention on the first day it was open for signature on 4th November 1950. The United Kingdom was the first country to ratify the Convention the following year. The United Kingdom will not be the first country to leave the Convention. The benefits of remaining within the Convention and retaining our position as a leader of the international community are seen by the government to be fundamental to our national interest." That's a Conservative Attorney General speaking. And he says in his speech that it's not just the coalition policy that they had to compromise on, but the policy of both parties. So there's an unequivocal statement that the British government will take what I think is the right approach. And yet, he goes on in this speech, and you can find it on the internet, I recommend you read it, because there's an air of make-believe to it as well. He goes on to talk about the British chairmanship and about the once-in-a-generation opportunity to reform the system and to rebalance between the decisions of the legislature and the decisions of the court. And he can't. He can't. There's nothing they can do by reform of the convention to achieve that. Here's an example of what he says that the government intends to do, because remember, they've got 10 MPs on both coalition parties and opposition, the whole mainstream, voting 10-1 against ever letting any prisoner vote on anything ever. So they've got to be seen to be doing something, and setting up this commission isn't going to be enough. The Attorney General says, here's an example of what they plan to do. We intend to redress the balance in the immigration rules by ensuring that they more fully reflect the compelling public interest in the maintenance of an effective immigration control. We take the view that Parliament, before whom these changes to the immigration rules will be laid, is best placed to decide on difficult policy questions, such as where the balance should be struck in relation to the deportation of foreign criminals. But it is important to note that in changing the rules, we will respect the jurisprudence of the Strasbourg Court and reflect the margin of appreciation that the Court has afforded to member states in coming to such decisions. Well, this is, the make-believe lies in the idea that they can redress the balance and give Parliament a predominant role in deciding how to strike the balance between the family interests of the illegal immigrant who's committed an offense and the public interest in deporting him to the country he came from. They can't redress that balance and still abide by the decisions of the Strasbourg Court, which is given by the European Convention the final jurisdiction to decide how that balance is to be struck. So there's a little picture of the political crisis, the predicament that the British government finds itself in. I think the future of that political crisis is simply an ongoing tension of the same kind that you find in American politics and in Canadian politics, but in a more acute form because of the international nature of the court that's making the decisions. Think back to the prisoner voting rights case in Canada, and take it from me that when the Australian High Court did the same thing, there wasn't a political crisis. There's a political crisis in Britain because it's foreign judges sitting in a foreign court in Strasbourg who are imposing that decision on the British Parliament. Now, I want to get into the proportionality question and that idea of balance that's in the Attorney General's speech, and he wants Parliament to take a predominant role in it, in deciding what the balance is, but of course, Parliament doesn't have that role and is not going to get it. The judges have it. Let's focus on this, the right that I mentioned, the right to respect for private and family life, and the way it affects deportation decisions. And it's done done using, the whole thing is done using that wonderful 6-syllable word, proportionality, in a technique that some say was developed using what Brian Dixon did in the Supreme Court of Canada in the early charter cases on Section 1. The European Convention doesn't have a Section 1, it has provisos to most of the rights, to all of the freedoms, and to a proviso to the right to respect for private and family life, which allows the freedoms to be restricted in ways that are necessary for certain stated purposes, very abstract purposes, as you'll see in respect of Article 8. And then the idea is that, and you know this from Canadian constitutional law, if you've done Canadian constitutional law, it's up to the court to decide whether there's some restriction on freedom of expression or on freedom of religion or in Britain, some interference with the family life or privacy of an individual. Whether it is done for the purpose of an objective that's legitimate, whether the interference is necessary in order to pursue the objective, and then if it is related to the objective and helps to promote the objective, and it is necessary and we couldn't pursue the objective in the same way with some lesser interference. Even then, the judges ask whether the impact on your freedom of expression or your family life is too much. Too much in light of what purposes? Well, here's the question. And the structure of proportionality gives us a sort of, or purports to give us a sort of scales in which we put something in both sides and see which way the scales swing down. In respect of Article 8, what goes in the scales? Well, remember we're talking about the deportation of someone who's illegally in the United Kingdom and has committed a criminal offense. And the courts are willing to allow that there is a legitimate public purpose to be served by deportation. So in one pan of the scales, you put the value in the public interest of deporting the illegal immigrant offender back to Bolivia, where he came from, in one of the interesting cases. What do you put in the other side of the scales? Well, in Article 8, the Convention recognizes that an interference with family life may be justifiable in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. So you put the effect on the family life of the offender on this side, and you put any, potentially, any good effect in the interest of national security, public safety, or economic well-being of the country, prevention of disorder or crime, or the protection of health or morals in the other side. Right? So that's what goes into the two sides of the balance. And so on the left-hand side, the court has to ask, how bad will it be for this offender? In the Bolivian case, he came on a student visa, stayed after the visa ran out, so he's illegally in the country, stayed for years, and was caught shoplifting. And the Home Secretary wants to send him back to Bolivia. And he has no legal entitlement to be in the United Kingdom. And he has a partner. He's been living with his partner for 4 years. So it's going to be bad for him if he has to go back to Bolivia. We can't, by the way, they're not supposed to suppose that it's worse to live in Bolivia than in the United Kingdom. Often, really often, particularly in the children cases, you sense an attitude among the judges that it'll be bad for this 2-year-old if she grows up in Bolivia or the Congo or Jamaica rather than the United Kingdom. But that's, and by the way, in children cases, there's a remarkable Supreme Court decision that says that the best interests of the child are the primary factor. Could conceivably be outweighed, but if you're an offender, and it would be perfectly fair to you to send you back to Bolivia or wherever you came from, but you have a child in London, and it would be good for her if you stayed in the country. That's the primary consideration. So offenders illegally in the United Kingdom with children nearly always win. Offenders without children, open question, but if you've had a partner for 4 years, then the courts ask, how hard would it be on your partner to have to go to Bolivia with you? And if they decide it wouldn't be reasonable to expect the partner to up sticks and move to Bolivia, then that's a consideration in favor of prohibiting the deportation. So that's the sort of thing. Does the kid need her dad? Does this partner, would it be hard for him to move to Bolivia with his partner, or how bad it will be if the relation breaks down as a result of the separation? That we judges need to Weigh that against what? National security, public safety, economic well-being of the country, prevention of disorder or crime, protection of health or morals, protection of the rights and freedoms of others. Whatever securing of those purposes would be achieved by deportation. And of course, the dramatic feature of this weighing is, number one, that these two values, the value of the person's family life and his family member's family life, on the one hand, and the public purposes are what legal philosophers call incommensurable. There aren't any shared units. The scales are just a pretense, really, because there is no rational ground for saying this much further badness for the family is equal to or greater than this much benefit in securing these public purposes. There are no units. We can't weigh these things against each other. But even more dramatically, in my view, no one knows. No one has said what the purposes are within the allowable purposes in Article 8 that are secured by immigration control. Why not have open borders? The British government isn't going to have open borders, but they've never said, Parliament has never said, what the rationale is for immigration control. There is no statement from the public authorities that are responsible for imposing border controls as to the purposes that are being achieved. So the courts are left to decide the public purpose in deporting a particular shoplifter who's illegally in the United Kingdom to Bolivia, if any. And there's an interesting issue. The courts, you might say, are not the body that ought to be deciding why we as a nation should have a deportation policy for illegal immigrants at all. But they're forced to do it. Or you might say they don't do it either. And if you read these cases, you will never find, in my experience, maybe I haven't read them all, I've never seen an articulate explanation of what, if any, public purpose would justify any impact at all on the person's family life. They're silent. The cases are silent. The government is silent. Parliament of the United Kingdom is silent on the public purposes that are being achieved by deportation. So there you have the court weighing the unmeasurable, the impact on the little girl or the partner or the offender himself, against a big question mark that's inarticulate. Now, I think it's, what I'm working on what I'm writing on this is an effort to deal with the following question. When we have judges weighing up incommensurables, do we lose the rule of law and just get the rule of judges, whatever that particular judge, his or her say-so, determines government policy? Let's face it, they are determining public government policy, and determines the fate of the individual, whether he or she is deported from the United Kingdom. Have we lost the rule of law and replaced it with the rule of judges in the European Convention mechanism? If the answer is yes, because of these incommensurables that the judges are weighing, then I think the answer would probably follow pretty swiftly that the answer is yes in Canada and in charter litigation where they do similar things. And I hope to explain why I think that's the case in the Insight case. We've lost the rule of judges here, the rule of law, and we've got the rule of Beverly McLaughlin and the other individuals. So life of the country is ruled by those individuals, their say-so, and not by stable principles of public order that are the standards of the community. So there's the question. When judges are weighing things together that cannot be rationally weighed with each other, have we lost the rule of law and replaced it with the rule of judges? And I think the answer is no, not necessarily. Not necessarily. And it's just a healthy reminder to us to remember that we have always had and we've always needed, and I think that every system with the rule of law needs institutions that will do the impossible Do the impossible, which is to weigh up incommensurables and decide which way the balance comes down when there's really no such thing as a balance. And I think perhaps the most striking example, and an example in which proportionality has always been deeply ingrained in Canadian law and English law, is sentencing of offenders for crimes. And always, let's not go back too far. Let's just keep the present regime in which we have serious prison sentences of incarceration for serious offenses. And the court in the sentencing decision needs to make a judgment of proportionality, and it's always been clear that that's what they were doing. And look at the two sides of the balance. In one side we put, what is it? I think it's the seriousness of the offense. But this is complex and we don't have time to analyze it properly, because it's not just the seriousness of the impact on the victims, but also the seriousness of the culpability of the person, the offender. And on the other side, we put a deprivation of liberty. And how much? Well, enough so that the scales come out even, so that the deprivation of liberty is proportionate to the seriousness of the offense. And the scales are just a pretense. There is no rational equation between 6 years or 3 years or 10 years for a serious armed robbery or for particular rape. And of course, these incommensurabilities are partly handled in every system by more or less arbitrary choices made sometimes by the legislature and sometimes by precedent as to the range of imprisonment that's available to the court. But still within those ranges, the court must look at all the circumstances. So except where legislatures adopt really arbitrary sentencing techniques and impose them on judges, which has happened in common law jurisdictions, of course, judges very commonly have the task of looking at all the circumstances, anything mitigating the culpability, but also looking at the culpability and the seriousness of what was done, and picking a period of imprisonment. Now, and there is no period of imprisonment that corresponds to the culpability and the seriousness involved in a rape or a manslaughter, which I think is a pretty fair generalization, even before we've looked at the facts of a particular case of manslaughter. We need judges to balance the unbalanceable. And I think it's interesting. This is actually, I think, a feature of remedies in general, if we think of criminal sanctions as remedies. And it's certainly the same in tort law, where general damages for personal injury require the court to pick a number, and it's got to be a determinate number. It can't be something substantial. It can't be roughly £10,000 or $50,000. It has to be $50,000, a number that you could write on the check if you're the defendant in a tort action. And there is no number of dollars that corresponds to the loss of a limb or to the loss of your mum or dad in an accident. So balancing the incommensurables is rationally impossible, and yet it's not irrational to have a system that purports to do it. In fact, it's essential to the rule of law. We couldn't have a community response to serious offenses that didn't make a determinate response of incarceration or whatever it is, in a situation in which there is no reason for one determinate response rather than another. And the same goes for general damages. And we could find similar phenomena of judges needing to reconcile incommensurable considerations on each side of the decision in areas of substantive law as well as in the laws of remedies. So we need judges to balance what's incommensurable, and the mere fact that judges are doing that in the deportation cases in Britain is not offensive to the rule of law. Here's something that I think is offensive to the rule of law. If they're doing so or purporting to do so in balancing things that shouldn't be balanced against each other, then we've left judges have left their necessary role of resolving things that have no rational resolution in the interests of the community. And we've ended up with the rule of judges. And I think, and if I'm running out of time, but if there's time in the discussion, I could explain why I think that's happened to some extent in deportation cases in Britain. And there are other ways in which we can lose the rule of law and end up with the rule of judges in respect of these decisions. And let me use the Insight case and just raise the question whether that's what's happened in Canada to some extent in one particular area of our life, which is the entitlement of heroin addicts in downtown Vancouver to come into a facility in which they can use the drug, unlawfully possessed by them before they come into the facility, unlawfully sold to them by a trafficker who's guilty of a serious criminal offense in selling the stuff to them, whether they can come into the facility and use the heroin in a safe environment in which they're given a clean needle and there's somebody standing by to save their life if they end up in an overdose or an injury to their health as a result of the use of the illegal drug. That's the regime in the Insight Clinic, set up in a remarkable federal, provincial, municipal partnership in 2008, and possible only because of an exemption from the prohibition on possession of heroin and the other drugs that are involved. An exemption under the federal drug legislation that prohibits possession of the narcotics, and made by an act of an exercise of discretion under the legislation by the federal minister, who has discretion to make exemptions for medical or scientific research purposes. He makes an exemption, or she makes an exemption, and says it will not be an offense under the statute for them to possess the drug when they come into the clinic. And the staff of the clinic won't be committing an offense when they cooperate in the use of the drug in the clinic. The Harper government, I think they gave them a lot of warning and said, we don't like this exemption, we're going to take it away. And they purported to take it away in 2008. And the clinic goes to court with I think the British Columbia government backing them all the way, and the Vancouver health system backing them all the way, and apparently the Vancouver police were in favor of this regime. The clinic goes to court and says, well, first of all, they try to say this legislation is invalid. I won't go into that because of the charter. But by the time it gets to the Supreme Court of Canada, the issue boils down to the claim by the clinic that the minister, in withdrawing the exemption, was violating the right to life, liberty, and security of the person in Section 7 of the Charter. And the Supreme Court of Canada agreed. Now, the Supreme Court of Canada pointed out the obvious, which all Canadian law students know, which is that doing something that's dangerous to your life or to the security of your person is not an infringement of your charter right unless it's done in a way that is not in accord with the fundamental principles of fundamental justice. Principles of fundamental justice, wonderful, evocative, abstract phrase in Section 7 of the Charter. And the court establishes to its satisfaction that withdrawing the exemption affects the life and the security of the person of the users of the drugs in the clinic, and affects the liberty of the staff of the clinic, because they won't be at liberty to do their job helping these people to use the heroin and protect their lives if it turns out that it was an overdose and so on. So it affects the liberty of the staff, the life, liberty, and security of the person of the users. And the question is whether it does so in a way that's in accordance with the principles of fundamental justice. And the Supreme Court of Canada, and by the way, here's someone I've been away from Canadian law for a long time and haven't kept up with it. But if I may say so, they enunciate what I think is the right question to ask. The question is whether this exemption is arbitrary. That's the term, arbitrary. If you arbitrarily do something that has this impact on the life, liberty, and security of the person, of the users, then you're not, you, the government minister, are not acting in accordance with the principles of fundamental justice, because the principles of fundamental justice require accountability of government action, not mere willfulness. Public decision-making based on reason, not arbitrary public decision-making. Arbitrary public decision-making isn't generally against the Charter, but if it affects your life or liberty or security of the person, then it violates your right under Section 7 of the Charter. I like that. I like that, and the really interesting question is how to work out what counts as arbitrary. And the Supreme Court of Canada's doctrine on it, well, actually there are two doctrines, and the Chief Justice says that she doesn't have to choose between them because this withdrawal of the exemption from the clinic was arbitrary on either one of them. One approach is that it's arbitrary if it's not necessary to achieve a purpose, and the other is that it's arbitrary if it's not linked to or doesn't help to achieve the purpose. Either way, this is arbitrary, they say, because it's not directed to a good purpose. The purpose in question would have to be related to the statute, the drug statute, and that's related to public health and safety. And the judges say, this is good for public health and safety, this clinic. It's not bad. So really, I think it's as simple as that. This clinic, they decide, is good for public health and safety. So the minister, in withdrawing the exemption, purportedly, in the interests of public health and safety, is not pursuing a valid objective. And if you're not pursuing a valid objective, you're acting arbitrarily. That's the Supreme Court's holding on that. Then, ironically, I think, they go on to say that it's also grossly disproportionate. I sort of think that remember the proportionality thing. Are you pursuing a valid, legitimate objective? If so, is the interference with the private interests necessary to achieve the objective? And even then, we'll ask whether the impact on the private interests is just too much. Well, they do that and decide that this was grossly proportionate when they've already found that it was arbitrary in the sense that it wasn't promoting a good public purpose, that it was arbitrary. So I don't know why they even have to talk about gross disproportionality. Let me read you the basis on which they hold that it was disproportionate. And it's in paragraph 131 of the decision. The trial judge's key findings are consistent with the information available to the minister and are those on which successive federal ministers have relied in granting exemption orders over almost 5 years, including the following facts. Number one, traditional criminal law prohibitions have done little to reduce drug use in the DTES, downtown Vancouver. It's probably a good generalization about prohibitions on drug use everywhere, anytime. So number one, traditional criminal law prohibitions have done little to reduce drug use. Number two, the risk to injection drug users of death and disease is reduced at the Insight Clinic when they do it under supervision of health professionals. Number three, the presence of Insight did not contribute to increased crime rates in downtown Vancouver. Those are the facts on which the Supreme Court of Canada bases its decision that this policy decision of the federal government was arbitrary, was not directed to a legitimate objective. Now, here's what I find remarkable about that idea that it was not directed to a legitimate objective. In the paragraph before the one I read you, the Chief Justice cites an earlier case in which the Supreme Court of Canada had held that the prohibition on marijuana does pursue a legitimate objective. Criminalization, this is the earlier case, seeks to take marijuana out of the hands of users and potential users so as to prevent the associated harm and to eliminate the market for traffickers. Supreme Court of, and they're not overturning that decision. The Supreme Court of Canada has accepted that prohibiting a narcotic in an effort to eliminate, even though we all know that drug legislation isn't very effective, the Supreme Court has accepted that taking the narcotic out of the hands of users and potential users so as to prevent the associated harm and to eliminate the market for traffickers is a legitimate objective. And 2 paragraphs later, they're saying that this government decision does not pursue a legitimate objective. Right? So I just don't understand that. My impression of the Insight case is that what they're doing is probably the best criminal and health policy that they could pursue. But I hesitate to say that, knowing no more than those 3 points, that traditional criminal prohibitions have done little to reduce drug use. The risk to the users is reduced in the Insight Clinic, and the Insight Clinic didn't produce an increase in drug use in downtown Vancouver. If I were the policymaker, I would want to know a lot more, and maybe there isn't anything to know. Maybe there's no good social science on what effect, if any, this idea of preventing the associated harm and eliminating the market for traffickers it actually achieves. But I'd want to know a lot more than the Supreme Court of Canada says before I decided Canada's drug policy. And on the basis of those features, the Supreme Court of Canada says that the policy that the Canadian government chose was arbitrary. I just think that's remarkable. I don't see how you can say that it doesn't pursue a legitimate objective, although I do share the sense that I think a lot of people would get knowing this, right? Knowing that they don't die as much, right? Heroin users in downtown Vancouver because of the Insight Clinic, right? It's obviously an important policy question whether we should forget about prohibiting heroin and find a response to the drug trade that takes this opportunity to prevent them from injecting themselves with something adulterated behind an apartment building and killing themselves, right? So there's obviously a policy question. I don't understand the Supreme Court's holding that the government was not pursuing a legitimate objective when they did this. And then the grossly disproportionate thing really becomes quite important. And if they hadn't held that it was arbitrary, you might say they might still have gone on to hold that it is grossly disproportionate. The effect of denying the services of Insight to the population it serves is grossly disproportionate to any benefit that Canada might derive from presenting a uniform stance on the possession of narcotics. Well, that's the next paragraph, and I do think that undercuts their claim that this is arbitrary. Any benefit Canada might derive from presenting a uniform stance on the possession of narcotics. Well, that's what presumably the government was trying to do, unless it was just trying to make a statement that we're tough on drugs or something, and I don't know what they were trying to do. But potentially they were trying to derive a benefit from presenting a uniform stance on the possession of narcotics. And it seems to me the only justification for this decision must be the judge's conclusion, stated in that one sentence, that the damage to people by closing down the clinic would be much, much worse than any benefit that the government was receiving. And then we really do have those judges making the country's drug policy. I don't know why there should be any prohibition on any narcotic if those judges think, oh, it'd be better if we didn't prohibit the narcotic. That's remarkable. And there's a really interesting comment by the Chief Justice a little bit earlier that you can find in the case. She says, it's for the government and the legislature to make policy, not for us. But when they turn their policy into action, we have to ask whether it's in accordance with the Charter. And that's right. That's exactly the right judicial policy. Policy making is for government. Deciding whether it's contrary to the Charter is for the court. And deciding whether it interferes with somebody's liberty in accordance with the principles of fundamental justice is for the court. And I think that the arbitrariness and disproportionality analysis in the Supreme Court's decision are potentially useful techniques for the court to control a policy decision that isn't fundamentally for the court to control. So I don't object to the arbitrariness standard or even the proportionality standard, and it doesn't in itself give us the rule of judges rather than the rule of law. But it potentially does, because of this remarkable incommensurability in the interests that needs to be resolved and is in our system, as in the British system, resolved by those judges, the balancing of the unbalanceables at stake in the Insight case. So there, I've stuck my neck out and told you what I think about the Insight decision. I haven't left as much time as I meant to, but I have left some time, and I'd love to answer any questions I can about what's going on in Britain, and I'd really value learning from you what you people think, and maybe not all of you have even heard of it or read it. But if you have what you think about the Insight decision, let me mention one more thing before I stop, which is the very end of the Insight decision. When they're deciding what remedy to give, and they could just issue a declaration that says it's not in accordance with the principles of fundamental justice for the government to affect these people's liberty and security of the person in this way. They could have just issued a declaration. They go further, and they issue what lawyers call a mandamus. And in doing that, the Chief Justice for the unanimous Supreme Court of Canada says, the only constitutional response to the application from the clinic for an exemption was to grant it. The minister is bound to exercise his discretion in accordance with the Charter. On the facts as found here, there can be only one response to grant the exemption. There is therefore nothing to be gained and much to be risked in sending the matter back to the minister for reconsideration. That sounds to me like a little declaration of war by the judges against the Harper government. Is that? I hope it's not too strong to say that. There's much to be risked by saying this is an infringement of the Charter and sending it back to the Harper government, to the minister for reconsideration. That's remarkable. Okay, I'd welcome any comments about the Insight case or anything else I've talked about.
Thank you very much. Thank you very much for a very thought-provoking presentation. So we have about 30 minutes for questions. So I'd invite questions. I'm going to circulate the microphone because we're recording this presentation just so that your voice is on the recording. So any questions? Anyone? Mohammed.
Thank you very much. I thoroughly enjoyed that talk, and there's obviously much in it there that I still have to think about. I don't know much about the British legal system and how it functions, but I'm more familiar with the Canadian Oakes test and the charter rights. And I was wondering about the rational connection part. So the Oakes test has two parts. The first, as you stated, the substantive question: does the law substantively connect with some goal that we're trying to achieve? And then if it's answered yes, we go to section 2, which looks at the rational connection, the minimal impairment, and the proportionality. And when you were talking about the deportation, I was wondering there if there's any connection between deportation and the stated goals that you highlighted. So there was public safety and all the other broad ones. Aren't there any other means to achieve those goals besides jumping right to deportation for individuals who have committed crimes on British soil? And if so, then is there a failure of rational connection there that can then get us out of this, potentially get us out of this mess?
Should I?
You have the microphone.
Oh, of course I do. Yeah. Thanks. Thanks. I said that the government has never articulated, and the courts don't actually articulate what the legitimate public purpose is. So they don't really get to your rational connection question. But I think it's fair to say that in these deportation cases, at least the ones affecting people who've been convicted of a criminal offense in Britain, they must be sort of taking it for granted that the legitimate purpose is getting the person out of the country when it's a person who has committed shoplifting or heroin trafficking and so conceivably might do it again. Of course, you can't exile a citizen in order to reduce the risk of shoplifting, right? But I think the idea is that a deportation is potentially justifiable in the interests of reducing crime if a person with no right to be in the country has committed an offense. And we also have to remember that all of these cases involve people who have no legal right to be in the United Kingdom anyway. And let's think about a case where no offense has been committed, and the Home Secretary simply learns that one of our wonderful students at Oxford has stayed beyond their visa and wants to send them back to Canada. Then the Home Secretary under British immigration legislation can do so. And again, the purposes are nobody's ever articulated the purposes. And you can imagine how in Britain it's a somewhat different calculus from Canada, which takes so many more immigrants than Britain takes. There is a sense that it's a crowded little country that can't take everyone who would like to immigrate to the country. For what? Because it would be bad for the economy. They'd all be on the NHS. So there's a lot of sort of populist rhetoric about it in the right-wing newspapers, and there's a lot of denigration of the populist rhetoric in the left-wing newspapers, and what you never see is any actual analysis of the benefits to Britain of open immigration and the potential costs or damage to the society that could result from open immigration. And that's what you would need if you were to find a legitimate purpose in the deportation in a case where there's no criminal element. Again, I think that the courts have taken it for granted that there's some sort of public policy justification for not simply having open borders. So it's not automatically disproportionate to send the former student back to Canada because there's some sort of purpose in immigration control, and nobody's ever told us what it is. And then they just have to weigh up the effect of the family life against something that hasn't been stated. So I think that they're by and large taking it for granted that there is some legitimate purpose, particularly when the person has committed an offense, which brings in crime control. And they assume that the deportation, number one, would promote that objective, and number two, they assume that the same thing couldn't be done by some alternative to deportation. And you might say that they're right to assume, take your question for granted and not even address it, if there's a purpose in immigration control in general. Because then, if there's a purpose in keeping the numbers in this little island to 70 million instead of 100 million, if that is a legitimate purpose, then shipping a person out is patently, rationally connected to it. On the crime prevention thing, and we can't keep the numbers by 70 million to 70 million if that's the legitimate purpose by some technique other than getting rid of the excess. But in the criminal case, there's a more interesting question about whether we could do something else with the shoplifter instead of sending him back to Bolivia, and I'm not aware that they've ever addressed it. Could I mention, by the way, that the same calculus arises in extradition cases. And here, and the extradition, so anybody, you're accused of a crime in Poland and they get an arrest warrant and they ask for your extradition from Britain or to America. Everyone who's extradited always uses Article 8, and they always get a hearing in front of a judge, and they always lose. And I think that they always lose because the answer to your question, they don't address it in the deportation cases. You might say the answer is obvious in the extradition cases. If somebody's accused of a crime in Poland or the United States, and there's a legitimate public purpose in cooperating with other nations in prosecutions so that nations don't become havens for fugitives from justice, then there's no way to pursue that objective other than the extradition. And then we have to balance the value of cooperating in extradition arrangements against the effect on your family life. And somehow, and they don't explain why, you always lose and you always get extradited.
Except for Roman Polanski.
Oh, no, when I say always, there are exceptions.
All right, well, I have two little questions, which might be big questions, but and what I think is a bigger one. The first question is, that's something of interest. You mentioned initially that, well, in Britain under the Human Rights Act, there's no remedial provision. The court can't invalidate statutes. Yet it can issue a declaration of invalidity. But you said that the newspapers tend to treat these declarations of invalidity as though the statute has been struck down. The question is, does the Parliament also think that? Is it the case that every time that that it's declared incompatible, they in fact look at it and try to accommodate and modify it such that there's, in a sense, a constitutional convention in England, in the Dacian sense, that's being created around this idea. So through the back door, there's a kind of popular Marbury and Madison that's happening in very British terms. So that's the first question. The second question has to do with, and that's just a clarification, you talk about this issue of incommensurability. You say when judges compare things they shouldn't compare that are incommensurable, then that might cause problem. Now, in everyday life, we compare all sorts of things, right? In fact, we could compare everything. And in fact, Jim Griffin in Oxford has a book on well-being where he says, actually, yes, everything is in theory comparable. Depends on the scale, right? And the real question is, should things be compared? So when you talk about judges compare things they shouldn't, what's the scale? What's the sort of the realm of value that they should refer to in making these comparisons? Big question, small, put briefly. And the last one that I want to put on the table is, I came to think about this by comparing the two cases that you discussed in England, right? The issue of the prisoners who are restricted in their
Francois, I have to start writing these down. Hold it.
Yeah, okay. I just want to put them all on the table, and then you answer whatever you want to answer. But so prisoners who are restricted or not in their right to vote, and the people who are sent away from the country because they committed an offense and they're not legally entitled to remain in the country in the first place. And then you ask, what's the position of judges, looking at these questions and whether it's them, qua judges, making these decisions or it's the rule of law. I'm wondering whether in this equation it matters as a question of, let's say, political theory, whether the person that the court is dealing with is a citizen in the first place, right? Somebody who is, in a sense, an official of the state, right? Somebody who is part of that collective enterprise that is the state. It seems to me that if somebody is a citizen, then that person may have certain claim vis-a-vis the courts, vis-a-vis the state, saying the state, I am part of you, qua citizen, you don't have a right, unless I turn against you and become an enemy through means of terrorism or treason, you don't have the right not to treat me as a citizen, right? You can't strip me of the right to vote. You can't kill me through, for example, the death penalty. It might be that you can help me realize what I did wrong by, for example, fining me or submitting me to certain rehabilitative process or potentially also imprisonment. But at least that person is a citizen in the first place and can say, well, my status prevents the state from interfering beyond a certain point. On the other case, the person is not a citizen, right? So it may be, if we adopt a certain cosmopolitan view of the world, to say, well, the state might have a duty to send that person away only to states that would treat that person as a citizen in that state. But when that person is in front of the courts of Britain and is not a citizen, then the state of Britain does not have the same kind of duty. The moral position is different, such that the question of whether the rule of law is respected or not in these cases might be differently answered depending on who the individual is and their relationship to the state, right? So 3 big questions, you say
Okay.
whatever you want.
Okay, thanks. The first one, the English lawyers don't tend to think of there being a constitutional convention when there is a regular custom accepted by everyone in question that Parliament should do this rather than that. They don't tend to talk about Parliament being subject to constitutional conventions, and I think that's a mistake. There are lots of constitutional conventions. The constitutional convention that the Queen approves legislation whether she likes it or not, and that's a real, genuine rule. There's no sanction for it. It's still a real, genuine rule. She knows what to do, what not to do, what would be wrong for her to do, and it would be wrong in virtue of the practice. So there's a rule that she has to, right? It's an act to ban hunting with dogs, and she has to sign it, right? There's a rule. Now, I think there are such rules that apply to Parliament, and that it would be wrong for Parliament to do certain things, and wrong in virtue of the customs of the institution. That's something controversial. But if I'm right about that, then the answer may be yes to your question whether there's a constitutional convention that they must make a remedial order, as it's called, in order to achieve what the courts say would be compatible with the convention. Whenever the courts find, an English court issues a declaration that a statute is compatible. I don't think there is such a convention. Certainly not in virtue of the misapprehension of the chattering classes that courts are striking down legislation. It really, you might say this is a question of interpretation of the Human Rights Act. And the Human Rights Act was deliberately designed to give to Parliament control over the question, how, if at all, are we going to respond once the courts have held it incompatible? So I think it's actually constitutionally important that they ought to, the conscientious MP standing up to vote on a remedial order, ought to treat it as an open question for the legislature whether to remedy the incompatibility that the judges have found. So there's my view. The practice isn't stable enough and isn't backed by the attitude of the political class as to how it's proper to vote in Parliament. Incommensurability and judges making decisions. Yeah, well, I do, I tried to say, and I'm trying to articulate in the thing I'm writing, that there's nothing in itself wrong with judges resolving a question where there are incommensurable considerations on each side. I do agree with you that we make such choices regularly in our own life. You've got 2 job opportunities, and one, the salary's higher, and the other one is closer to home and would be more fun. But the salary's quite a bit higher, right? And in that sort of situation, so job A in the florist around the corner, job B in the insurance office across town. Well, obviously you want the job in the florist close to home. That's much more fun, and you'll have more time to spend with your kids. But the salary is $25,000 in the florist, and it's $45,000 at the insurance. Tough question, potentially, and it's easy to imagine that in such a case you might be in doubt which is the best, and there may be no rational answer to the question which is the best. And it may be that if they offered to raise the salary by $1,000 at the florist, that wouldn't settle the matter. And if that's the case, then I think you've got a sort of badge, we might call it a badge of incommensurability. If an increment in the value of one of the options where you're not sure which is best, well, but an increment in the value of one of the job choices, if that won't settle the matter, then your problem wasn't that they were exactly equal, and right now the job in the florist is clearly better. The values that you could achieve by pursuing one job rather than the other are not rationally balanceable with the values you could pursue by taking the other choice. And It's not impossible to choose, that's true. And yet I think it is an important feature of practical reasoning that there may be no rational basis for one choice rather than another, but you can still choose. And as you work on it, you start to talk yourself into one job rather than the other. And you start to, I think it's a common psychological process, to start to discount the values in one job as you try to work this out and end up, often I think, very often people end up in that sort of situation, persuading themselves that one option is clearly better than the other. Now, and that's fine, and we need to do that. How about this? Your mom could do it, right? If there's no rational basis, assume there's no rational basis for saying that's the right job or that's the right job, then you could ask your mom. And she could say, take the job at the insurance agent. Right? Now, and the fact that there's no rational basis for choosing one rather than the other means that getting your mum to decide is not making the mistake of failing to act on the value of the jobs, because by definition, the value of the jobs doesn't decide the matter. And yet it might be a really, 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 really bad mistake to get your mum to choose, right? It might be your responsibility to resolve these incommensurabilities. And it might be bad for your relationship or bad for your own emotional health to get your mum to choose. So there, and I mentioned that thing about your mum because in the judicial situation, what I want to say is that the fact that there are incommensurably important considerations on each side does not mean that we're losing the rule of law when judges decide it, not in itself. But it is possible that judges are the wrong people to be resolving these incommensurabilities. So it isn't necessarily an abandonment of the rule of law to have judges making a decision where there's no rational basis for a decision one way or the other. But it's possible. The last question, I'm not really sure I understood it. I think the distinction between citizen and non-citizen is profoundly irrelevant for certain purposes and crucially important for others. It's the difference between deportation and exile, right? The heroin trafficker, if we send him to Australia because he's a heroin trafficker and he's a citizen, that's a tyrannical abuse. If we send him to Australia because he's a heroin trafficker and he's Australian, it's potentially not abusive at all. So citizenship makes a vital difference. But if we have a nice wing of the prison for heroin traffickers who are citizen and a nasty wing of the prison for dodgy foreign heroin traffickers, I think that's an abuse. Citizenship is completely irrelevant. I've written something arguing that citizenship is completely irrelevant to habeas corpus. Should not be an issue, should never have been an issue in the protracted litigation over Guantanamo Bay in the United States. Completely irrelevant. And has been irrelevant in English law, I think, for centuries. So the relevance of citizenship to rights really depends on the right in question, I think. And also on the nature of citizenship, which can be different in one regime than another. But, sorry, I wanted to say that. I knew I wanted to say that when you were asking the question, but I didn't really understand the question. So can you state it again?
So the kind of rights that we're talking about are constitutional rights. We can choose to think about them also as mimicking human rights, but first and foremost, they are constitutional rights.
Yeah.
And what is the nature of a constitutional right vis-a-vis a human right? Is it the fact that they are the rights of a certain set?
Okay, thanks. Yeah, good. Then what I said about habeas corpus is actually relevant to this. Because I think that it would be tempting to say that human rights are rights that humans have, so citizenship is irrelevant, but constitutional rights, the Constitution sets out the rights of the citizens. It is the framework for our polity And so members of the polity have rights and have constitutional rights. Human beings have human rights, and the two are different. Well, I think that constitutional rights and human rights are different things, but I think that it's a really, really bad mistake to think that constitutional rights are rights of the citizen. Certainly, a good constitution is likely to enshrine rights that are held by citizens only. But habeas corpus is an element in the British Constitution and in the American Constitution and in the Canadian Constitution. And as I've said, I've written something arguing that it would be a mistaken understanding of the Constitution to think that the habeas corpus protection is a protection for citizens. It is, of course, but it's a protection for the citizens just in application of its rationale. And the rationale of habeas corpus is not to protect citizens from abuse by the government, but to create a constitution, create a political order in which and that's the citizens, our Canadian officials act responsibly on our behalf with justice in certain areas of the life of the community that need to be regulated by the Constitution. And I think that a good constitution will prohibit arbitrary detention of non-citizens for exactly the same reasons, for exactly the same constitutional reasons that it prohibits arbitrary detention of, did I say citizens the first time? Non-citizens, citizens, same thing. Our Constitution ought to create a police power and a military power, and ought to hold the institutions that have those responsibilities accountable to judicial institutions, not for everything, not for all issues, but in respect of the detention of a person, we, the people, right, to use the American phrase, we the people, through our constitutional structure, should have judicial techniques for holding the people with the guns accountable for detention and for engaging in it only in a way that's in accord with the principles of fundamental justice. Section 7 is an element in the Canadian Constitution that protects non-citizen and citizen for exactly the same reasons. So there.
So I'm just in my first year, so I'm pretty ignorant here. But if I understood you correctly, you said that the right to vote for prisoners isn't necessarily a human rights issue, or in comparison to a human rights issue, it's trivial. Is that correct? That struck me, I sort of immediately disagreed with that, only because I imagine that for a prisoner, the right to vote is the only means by which they have access to the right to liberty, because by electing a new government could potentially affect their imprisonment, right? Depending on what the platform has. And then as an extension of that as well, if you were to take away the right to vote from prisoners, then you could potentially eliminate a motivation for new governments to cater to their needs or interests at all. And so you are essentially treating them as a non-citizen. You're just not taking them into account at all. Yeah. So.
Okay, thanks. Yeah, and you've got all the judges of the Australian High Court and the Canadian Supreme Court and the European Court of Human Rights on your side. And I actually think that the strongest argument in favor of prisoner voting as a right, I do think it's a good policy. The strongest argument in favor of it as a right is something that I think you've articulated and runs basically like this, that the point of the election, particularly federal elections in Canada, the point of a national election, but local as well, is to secure the representation of the people and the voice of the people. And that means that we need the voice of different groups, different interest groups. And there is a potential that prisoners, as a voting bloc, have an interest that ought to be reflected in the decisions, in the election decision itself, and in the structure and in the government that goes on to work on their behalf. Because I do think that a good government is working on behalf of rapists, right? Murderers, as well as on behalf of nice people. And really, when he says when the Prime Minister of the United Kingdom says it makes him physically ill to think of giving Hearst the right to vote, a murderer the right to vote, I think he's falling into the danger of treating prisoners as bad guys, and bad guys shouldn't have good things, and voting is a good thing, or thinking of voting as something that must reflect practical wisdom and niceness, and then unwise rapists or murderers shouldn't be contributing to decide who should run us. Those are all, I think those are all mistakes. But I think that the deprivation of the vote is not an unfair punishment. I think and it's not an assault on the person's dignity. Imprisonment is a massive assault on a person's dignity, I think. Justifiable only on grounds of necessity that nobody has really very effectively established. I think there's a huge question as to whether our imprisonment practices are justifiable. But in terms of, as a punishment, saying to somebody, if you commit an imprisonable offense, we are not going to let you vote, I don't think that's unfair. Right? I don't think that's unfair. I don't think it's an assault on human dignity in a process that's laid down in the law on the sentence of imprisonment for of a court to say that we're taking away from you your liberty, including the freedom to vote. I don't think that's unfair. Let's put it that way. But I am a bit ambivalent about that one question about the purpose of the election and the representation of the people and the value of having the vote. And here are the 234 MPs in Britain who are shouting and voting in favor of this resolution that no prisoner should ever vote. They would deeply disagree with you and me, because they would say that it's democratically important that we don't have our representatives chosen by axe murderers and heroin traffickers.
So back to this question of incommensurability. I think an economist would respond to that by saying everything's commensurable because we have utilities. So how does your argument respond to that?
Well, yeah, I mean, it follows from what I've said that would be wrong. And I'd go further and say that that's an absurdity, to think that everything is commensurable. There's a temptation to conclude that Bentham thought that, Jeremy Bentham thought that, that we could in principle come up with units of utility, and then you just haven't enough insight into yourself when you say to yourself, it'd be fun to work at the florist and it's right around the corner, but I'd make nearly twice as much and I could do stuff with the money and get a nicer car. I don't know which is better. And in fact, there's no reason for choosing one rather than the other, but they'd both be good and I've got to choose one. According to Bentham, you'd be making a mistake that arises out of insufficient insight into your own, the reasons for action that you have. And in principle, we could put units on the value of these different goods. And by the way, units on what might be called the disvalue of the longer trip to the job in the insurance agent, or the boredom of going through forms when you could be making bouquets. And then we have a calculus. And that's attractive to someone like Bentham and to some economists, not all. A lot of economists would not agree with this at all. It's attractive because of the potential, the sort of model of rationality that it holds out to us. If only we understood ourselves and the relevant considerations better, then there'd be an answer. I think that's an attractive thought, but it's illusory, I think. Money, and perhaps this is one of the reasons why economists find the idea attractive. Money has a beautiful commensurating effect, because a chocolate bar, the value of a chocolate bar and the value of a can of Coke, they're both good. If you can only buy one, there may be no reason, in my view, to pick one rather than the other. But put a price on them, and that seems to sort of clarify the problem. And you might say, the point that the economist would have, or that Bentham would have, is that it is a truth that any of us, attracted by the chocolate bar, for any of us, there is a point at which we would say, oh, that's too expensive, and a point at which we would not say that's too expensive, but would be willing to pay for it. And I think that Bentham, or the economists you have in mind, would say there, that phenomenon, the price rises on the chocolate bar and she's buying one every morning with her cup of coffee, and then she stops because it's got too expensive. That shows the units of utility reflects the units of utility in the chocolate bar. But I think it's important that that's not necessarily so, that the fact that somebody makes a choice does not imply either that there was rational ground for the choice, or that they saw, or that even that they thought that there was a rational reason for the choice. So there you go, it's a pretty fundamental disagreement. Ronald Dworkin, who's not a utilitarian, thinks that basically all values are commensurable. With some exceptions, he's willing to admit that there may be no right answer to the question whether Mozart or Picasso was the greater artist. But he would say that there will be a right answer to the question whether Mozart or Beethoven was the greater artist. And he'd say that there absolutely, definitely has to be a right answer to any legal question where somebody else is saying that the values at stake are incommensurable. Now, these economists that you have in mind, presumably they would have to say that there is a right answer to the question whether Mozart or Picasso is the greater artist, would they? Do you think that's the case?
I think they would just look at the value of
At the value?
or the utility of the arts to the people who are enjoying it.
To the people. How do you measure the utility to the people? Yeah, that's what I say too. Okay. Maybe we agree. Thanks.
Unfortunately, we've run out of time, so please join me in thanking Professor Endicott for a wonderful presentation and Q&A. Thank you very much.
Thanks.